All right, we got a lot to talk about, so we're going to go ahead and get started as other people filter in. Welcome, everyone. My name is Michael Carroll. I'm the co-faculty director of the program on information justice and intellectual property here at the American University Washington College of Law. This event is part of our ongoing IP and Tech at the Supreme Court series. We've initially focused only on intellectual property cases before the court and then have expanded as the court is now starting to engage with the internet and related technologies more directly. This series started in 2012, so thank you to all of our panelists for joining. Um, and thank you for those of us in attendance. We're going to have a very interesting discussion. In a minute, I'm going to let our panelists introduce themselves as they explain what their interest in the case is. I'm very briefly going to set up the case to make sure that if folks haven't been following this closely, that you have a basic understanding of the vocabulary that you're going to be hearing. And from there, we're going to talk a little bit about the merits of the case and then focus on what we learned from today's argument. Okay, so this is Chatrie versus the United States. It involves a question of whether a search was permissible under the Fourth Amendment of the Constitution, which gives people the right to be secure in their persons, houses, papers against unreasonable searches. And a warrant should not be issued except upon probable cause, and it must particularly describe the place to be searched. Um, so what happened? There was a bank robbery on May 20th, 2019. A warrant was sought to get location data associated with any mobile device that Google had data on in the vicinity at the relevant time. We'll talk about the specifics in a minute, but that is what is called a geofence warrant. I want all of the cell phone location or information about cell phones inside the geofence within a particular time. The data that Google was collecting was based on an opt-in feature called location services that would record and track real-time location data. And at the time, about 1/3 of users had opted in. Um, so in this case, the law enforcement officer arrived at the scene of the bank, and there was security footage showing that the person who committed the robbery was on a cell phone as he walked into the building from the southwest corner. Using that information, the officer sought a judicial warrant and obtained a warrant that would allow a obtaining of information from Google in 3 steps. There's only one warrant. But these were the 3 steps that were outlined. Step 1, get anonymized data of devices within a 150-meter radius or 300-meter diameter of a specific location during a 1-hour period, 30 minutes on either side of the crime. Step 2, narrow down the request. Now, the officer did not initially do that and asked Google to give expanded data on all 19 device accounts. Google refused, so then the officer and Google came to an agreement that they would get 9 devices, would get additional information, which would be expanding the time period to an hour on either side of the event and taking away the geographic limitation to track movements outside the geofence area. Based on that data, the officer identified 3 devices that appeared to be potentially associated with the robbery, including potentially a getaway car, and asked Google to de-anonymize the user data for those 3 specific devices, one of which was Chatrie's. So the legal questions, there's one question presented about whether this violates the Fourth Amendment, but the Fourth Amendment prohibits unreasonable searches, and that breaks down into 2 pieces. First, the question is, was obtaining this data a search? And the court has told us it's a search either if Chatrie had a reasonable expectation of privacy in that location data, even though he was in a public location, or alternatively, and somewhat novelly, did Chatrie have a property right in that data such that there was a violation of a property interest? And there was some discussion today about how even the property interest might inform the first question. If this was a search, was it a reasonable search? Well, a warrant was obtained, but is it the kind of warrant that makes a search reasonable, and in particular, did the warrant meet the particularity requirement generally? And should additional warrants have been necessary at steps 2 or 3, or sort of subsidiary issues in the case? One thing to keep in mind is that this is now a series of cases in which the Supreme Court is looking at the Fourth Amendment in the technology context and feeling some pressure to adapt some of its pre-existing exceptions to the warrant requirement. So in Carpenter versus United States, the court decided not to accept any of three possible exceptions and held that it was an unreasonable search when law enforcement collected 127 days worth of cell site location information, which tracked the location of Carpenter's cell phone over that period of time, even though the movements were in public places in plain view, many of them. The court nonetheless said there was a reasonable expectation of privacy based on the scale and scope of that data. So how does that apply in this case where the data is only for, at least at step 1, only for a 1-hour period? Are these material factual differences? So those are just a few of the questions. There's some other precedents, of course, that were referred to, and some other issues, but that at least gives you some indication of the two basic questions. Was it a search? If so, was it a reasonable search? Is our structure? And I'm going to first ask Laurel Raymond to introduce herself. Tell us a little bit about your role in the case.
Yeah, hi everyone. My name is Laurel Raymond, and I am one of the team representing Mr. Chatrie. So we're representing the petitioner in this case, and I work at Jenner and Block. Um, and so just diving into the merits as you can.
Well, let me introduce everyone else, and then I'm
Oh,
going to
okay.
come back and
Of
ask
course.
for that. Caitlin, tell us who you are.
Hey y'all, sorry if my voice is a little tired. I was at the court at 4 a.m. with some people I see in the chat. My name is Caitlin Ringrose. I'm a security and privacy attorney at a global firm called McDermott Will and Schulte, where I focus on data flows. Previous to this role, I served as Google's global policy lead for law enforcement and government access. So I did work on cases like these. I published Google's geofence transparency report. My relationship to the case is pretty strong. My very first month at Google came right after the January 6th geofence, which was highly publicized, and I left about a month after location rolled on device. So it's a very full circle moment attending today's arguments on behalf of my client, Center for Democracy and Technology, a nonprofit advocating for digital rights and freedom of expression. And I do see CDT's Security and Surveillance Project folks in the chat. So Greg and Jake, definitely answer questions, pitch in as we discuss your brief.
Excellent. And Laura.
Hi, yeah, my name is Laura Bondink. I am the manager of legal programs at the Cato Institute. And before coming to Cato, I was a trial attorney in the state of Michigan, and I did both criminal and civil cases. So I myself had a little experience with Fourth Amendment motions at the trial level. I was also one of the authors on Cato's amicus brief supporting Petitioner Chatrie in this case.
Great. And then switching sides, the United States never participates in these events. It won't comment on pending litigation, but we have on the respondent side, Eric, tell us about who you are and what your role is.
Sure. My name is Eric Wesson. I am the Solicitor General for the state of Iowa in the Iowa Attorney General's office. The Iowa Attorney General co-led a bipartisan amicus brief along with the Attorney General of Michigan, supporting the United States' approach here. And I'm looking forward to discussing both our amicus and this case with all of you.
Great, thank you so much. And last but certainly not least is my relatively recently joined colleague Veronica Miranda, who is directing in our Tech Law and Security program, which is a sister program of our IP program, and we work closely together and have shared interest in cases like this. So Veronica, and Veronica has agreed to step in and tell us a little bit about the United States position in this case, since they wouldn't participate.
Yes, hi. Thank you, Mike. I'm the Associate Director of TLS here at AU. Though most recently, I spent about just under 3 years at Microsoft working in their law enforcement response team. And before that, 20 years at the FBI, where I did work some in-depth issues related to many warrants, but especially geofence warrants. However, I will say in caveat, as lawyers that we all are, that I am not currently in the government, and anything that I say here is from my interpretation of what the government filed, not from my knowledge when I was a government employee. So I just wanted to make that little caveat, but I'm excited to have this conversation.
Great. All right, so let's hear about the merits. So Laurel, you petitioned the court, and there's a complicated procedural history. The one of the issues that didn't get granted cert was the good faith exception to the warrant requirement, which is what the trial court relied on. And then we had a Fourth Circuit panel that affirmed on one ground. We had an en banc Fourth Circuit case that affirmed on a different grounds, with 9 of the judges also agreeing on the good faith question that's not before the court, although Alito tried to bring it in. So you had a complicated path, or this case had a complicated path to the petition stage. So why don't you take us from there? Once the petition gets granted, what did you present the court with?
Yeah, and I think you're right. This was a very complicated path towards. This case has been going for 7 years. There's a lot of positions on either side, and there's a lot of positions in this case. So I'll do my best to keep the moving parts all clear. So starting with the first question, the question is there a search? So that means, is there a protectable interest that the Fourth Amendment covers? And we think yes, and we think yes for 2 separate reasons. The first, I'll start with the property interest, because we think that actually informs the reasonable expectation of privacy in some ways. But basically, the Fourth Amendment protects things that you have a property interest in, and at common law, property was defined as sort of a bundle of sticks, a bundle of rights, and we think that location history data actually matches onto that bundle of sticks quite well. You can use it. It is designed for you to view. You can export it. If you wanted to, you could export it and sell it, so you can alienate it. You can edit it. You can exclude people from it. It's in your password protected account. And you can destroy it. You can delete it. You can tell Google to delete it. And we think that indicates that it is something that is yours. And therefore you have a property interest in it, and it is covered by the Fourth Amendment. And second, if you don't buy that theory, we also think you have a reasonable expectation of privacy in it under Carpenter. Location history data is comprehensive, it is detailed, it can track it tracks your location every 2 minutes down to can be up to 3 meters. It could reveal the intricacies of your private life. It is retrospective, and we think that's very important. And easily compiled. So functionally what that means is you are tailed at every moment of your life, and the government can go back and pick a time and a place and draw a circle around it and say who is here, and you'll effectively have been tailed there. And we also think that there's no reasonable expectation that in saying, yes, Google, you can collect this data for me to use, that means that the government can also access that data. We think that no reasonable person saying yes would understand that. And then I'll just say, just a small aside, the government is going to say that this is covered under the third-party doctrine, and because you voluntarily turned your data over to Google. We don't think that's right. First, we think that when you turn your data over to Google, Google is acting like a bailee, similar to how if you turn a letter over to the post office, it's still your letter. And second, the third-party doctrine applies to business records. Google has specifically said these are not business records of Google's. And third, we think under Carpenter, Carpenter said that even if they are business records for particularly sensitive data, the third-party doctrine does not apply, and we think this fits squarely within that. So then turning to the second question, once you find that this was a search, once you find that there was a protected interest, you need a warrant, and they did in fact get a warrant here, mostly because Google required it. And so the question then becomes, does this warrant comply with the Fourth Amendment? And We think no for multiple reasons. So first, warrants require you to particularly describe the place to be searched and the things to be seized. And this warrant just identified Google as the place. And if that's right, then the government could say, Google, please search all of your email accounts for like one email containing details about the about like an upcoming shooting or something like that. And we think that instead, like you have to identify the particular account because each account is a distinct place. And so because this warrant did not identify the distinct account, it just said Google search all of the accounts. That this is strikingly similar to a general warrant, which is what the Fourth Amendment was actually enacted to prevent. And then second, we also think if you don't buy that theory, and spoiler alert, I don't think the court did, that that there's still not probable cause here presented to the magistrate to support a geofence of this size. That is to get the location history data of 19 people and tail them for an hour, particularly because, you know, if you actually look at the warrant and the results, like most of these people were just sitting in church the whole time. And there's not really any evidence that any idea that they would have evidence on the crime that occurred in the bank next door. And third, we also think that this warrant was defective because it conferred unfettered discretion to law enforcement to expand the scope of the search for particular users that law enforcement, in their discretion, deemed to be the most suspicious without going back to the magistrate. So at step 2, the warrant allowed, without going back to the magistrate, the police officer to say, I think this subset of people are more suspicious. I want more information on them. And Google turns that over, and that actually tails them outside the geofence, including some people to their homes. And then at step 3, it allows the magistrate to say, okay, for this subset, which turned out to be 3 devices, we want to know exactly who they are. And we think that at a minimum, you have to go back to the magistrate before you get that extra data. And so that is a very quick rundown of all of our positions.
Well done. And it does explain how many steps in the analysis are required if you trace it all the way down. Okay, so the role of amicus is to help out and not duplicate what the parties had to say. So Caitlin, and what did your brief add to what we just heard?
Yeah, there were so many amicus in this case, Mike. I think it's astronomical. There's 26 amici briefs filed, and our amicus, CDT's amicus, was actually entered on behalf of other privacy organizations as well. And so there, we were really focused on the technologist's point of view, the privacy point of view, and we, I think, complemented Google's brief very helpfully. So we argued essentially that geofence warrants represent a dangerous inversion of the Fourth Amendment. So instead of requiring individualized suspicion as a prerequisite for a search or engaging in that traditional process of finding a suspect and then asking for evidence pursuant to that investigation, these warrants allow the government to search through records and accounts of innocent people to find a needle in a haystack, right? And we assert there that location history data, which is different than cell site location information, and we can get into that. It is highly precise, and it is a sense-enhancing technology that provides this intimate map of a person's private life, including their associations, their religious practices, and political activities. Even here, we saw that the fence encompassed a church. As Laurel mentioned, location history is incredibly granular. It is unlike cell site location information, CSLI, in that location history is not kept to the benefit of cell provider or to Google. It is instead chosen by a user for their own enjoyment and use. It is essentially a digital journal of one's movements. And that is what users use it for. They log into Timeline. They're able to see their past visits. They're able to see what restaurant they liked when they visited Paris a few months ago. And so it's really important to see this as a function for a user to use at their own enjoyment. We also contended that the voluntariness of sharing this data, which is a point often cited by the government under the third-party doctrine, it's really a legal fiction here. It's impossible or implausible to believe that individuals are going to turn their cell phones off before entering into any protest, going to church, merely being in a space where they desire a degree of privacy. Now that we have phones, now that we're potentially Android users, and we're those 1/3 of Android users who've opted into location history, it is fairly unlikely to believe that we're just going to go around turning our devices off. And here, this is a very police in our pockets moment. Finally, we did warn that upholding this warrant, and Laurel, I know that Adam and Mike covered this really well in today's argument, could authorize further digital dragnets that would chill the exercise of First Amendment rights. So, for example, there are other reverse techniques that law enforcement may or may not be using. Sometimes it's hard to tell, that would rely on the very similar understanding of particularity as that posed by the geofence. And so you could imagine a reverse IP search, a reverse search for someone's AI prompt or request, a reverse address lookup or partial lookup, as well as a reverse keyword. And so today's case doesn't just matter for Google geofences, but could have a much broader impact.
Great. And then Laura, Cato has a specific view about the role of the government in our society. How did that inform the position you all took before the court?
Yeah, for those that don't know, Cato promotes a limited role for the government in society. But with our amicus brief in this case, we really wanted to raise 3 big points for the court in a complement to petitioner's brief. First, we explained why a textual analysis is likely a better approach to determining when a search occurs for for purposes of the Fourth Amendment, rather than the reasonable expectation of privacy test that most courts default to. Next, we urge the court to decide this specific case based on the property theory of the Fourth Amendment, asserting that contract law and positive law support the conclusion that users own their digital location records. And finally, we explained that the geofence in this case attempted to or the geofence warrant in this case, attempted to authorize 3 distinct searches, each one more invasive than the last, and each requiring a separate particularized warrant independently supported by probable cause. So turning to our first argument, we asked the court to employ a textual analysis of search. Today, most courts default to the reasonable expectation of privacy test, which asks whether society considers something reasonably private as to warrant Fourth Amendment protection. But unfortunately, this test has produced some counterintuitive results and sometimes leads to a conclusion that a search is not actually a search, like when the government flies a helicopter or a Cessna plane over a backyard to see past a privacy fence. Rather than continue down that path, we would ask the court to return to the original public meaning of the word search, which meant the same thing at the founding as it does today. It's an investigatory act carried out with the purpose of revealing private information. And that understanding traces back to English common law, and it directly informed the framers' understanding of what constitutes an unreasonable search. And by returning to the original public meaning, the court's analysis will be more faithful to the constitutional text and actually simplify the search inquiry. The second point our brief makes is that property is not a secondary consideration, but rather the foundation of the Fourth Amendment. Property rights don't dissolve merely because one shares their information or because a third party stores information for that person. And when a person can show ownership of the thing that the government has examined, the Fourth Amendment analysis can begin and largely end right there. But that sort of leaves the question, what does ownership of digital records look like? Our brief argues that contract law allocates property interests and can inform a court's decision under the property theory of the Fourth Amendment. And here, Google's terms of service give users the ability to download, restrict access to, and delete their digital records. And Google itself described these records as a user's diary and said that it stores these records primarily for the user's own use and benefit. That language of control and exclusion is the very essence of property. Moreover, state law reinforces this conclusion, and more than half of states now expressly define digital data and electronic records as personal property, including Virginia, where this case originates. This reflects a broad democratic consensus that when a user's actions generate data about them, that data belongs to them, not the platform that stores it. And the Supreme Court has long used positive law as a guide in determining the scope of constitutional protections, most notably in the context of the Takings Clause, and we would ask that the same logic be applied here. Not only does the property-based approach make it easier for courts to determine the scope of constitutional protections, it avoids the problem of courts engaging in judicial guesswork to determine what may or may not be reasonably private enough to warrant protection. And then the third and final point we argue is that the geofence warrant in this case authorized 3 separate and distinct searches, each of which requires a separate, sufficiently particularized warrant supported by probable cause. Each step of this geofence process was more than just a simple refinement of one inquiry. Rather, each step was a successive invasion, each one deeper than the last. But by structuring the warrant around a 3-step process that permits law enforcement to review progressively more sensitive information without ever returning to a magistrate, the government effectively secures a blank check. And we would argue that this goes against what the Fourth Amendment permits. In Ibarra versus Illinois, the Supreme Court struck down the government's decision to search bar patrons pursuant to a valid search warrant for a bar because it held that the discretionary search of the patrons exceeded the scope of the judicially approved warrant. And we argue that the geofence warrant in this case suffers the same constitutional deficiency in that law enforcement, not a magistrate, is the one determining the parameters of the search. We go on to argue that allowing these types of successive and invasive examinations without an intervening check by a judge or magistrate sets dangerous precedent. Geofence warrants are becoming a routine law enforcement tool, and if a single warrant can authorize cascading and increasingly invasive searches of millions of Americans' digital records, the Fourth Amendment will become effectively meaningless in the context of personal information stored by a third party in the cloud.
Okay, great. Veronica, I think I'm going to ask you, I mean, the United States takes a different view. They are becoming common because they can be pretty effective investigative tools. So how did the government defend their constitutionality?
So trying to be, this is rough, like we've been saying, there's so many different issues and you're going to tackle each one of them. So in the government's view, starting with the most basic, it was that this was not a search, that there was no reasonable, as has been explained, there was no reasonable expectation of privacy in the voluntariness of providing this information to Google by opting in. I know that there has been from petitioners' parties, as has been discussed here, a lot of discussion on how this was a record, that it was like a diary, and the Google created it for the user. What Google also admitted was that really they created this for their own business purposes, for advertising, and to be able to target ads and other business type uses. And Google reserved the right basically to access this data, these location points. And they would tell people that they could opt in, or but if they decided not to opt in, that their systems may not work as well. So they were transmitting the information that this was something that helped their business. So to say that that this was completely personal record that belongs to the user is not necessarily how it played out in reality, where Google was the one who determined, unlike an email, for example, if I do email via Gmail, Google Mail, I write that email, I draft it, I created it, I create the account, and I do put a password on it, right? And the argument is, well, this was stored in the account of the person, the password protected account. Well, the account may be password protected, but the database that Google stored this at the time, their sensor vault, was a database that stored everything together, anonymized. So there were no names, no way to identify anybody. So, and Google could access it. And the fact that Google responded to the warrant shows that they believed that they had the legal authority, as it says in their terms, that if there was a valid legal demand, that they could respond to it. Just the same as they respond for an email account. Now, I know the argument has been made that, well, an email account is an individualized account, but here there is no, there are warrants, and the Supreme Court has authorized not a general warrant. This was not a general warrant, but rather this was a warrant that was specific because there was a crime that was committed and there was a fence around the specific locality of the bank, looking for witnesses and suspects. The law enforcement was clear explaining to the magistrate that this was the purpose of this warrant and this were the purpose of the 3 steps. The 3 steps were meant to be minimizing, not expanding. The law enforcement did not search millions of accounts. Google, in response to a law enforcement valid warrant, ran a filter, an automated filter, against a database that they had access to, that they were allowed to reach into, and pull out a list of anonymized users, not just random numbers. And the government narrowed that. First of all, they only got 19. So the government did not go and look into millions of innocent accounts. Again, Google ran a automated filter against however many accounts they had. The number of millions have been thrown out, but the government didn't know how many. It could have been 1 million, it could have been 20, it could have been 10,000. The government did not know, and the government did not see that information. So it wasn't a government violation of anybody's Fourth Amendment rights, including Chatrie's. So even if you say that, again, so going through the first steps, it was not a search. In terms of the property-based interest, again, I've briefly touched on the fact that this was not, in the government's position was this was not a property that belonged to Chatrie. Even though he did have access to it, people can delete that information. Yes, that is all correct. But it was a Google created and a Google data point that while the user could benefit from it, it was really mostly created for Google's ad revenue business. So not a search, not property-based, voluntariness. And also, unlike CSLI, as we talked about, cell site location information, that was also distinguishable in this case. That was something that basically was required for the phone to work. Here, this was something that was optional. And so that all plays against this idea that there was a Fourth Amendment violation here because this was a record that a personal data rather than a business record. So in terms of, I'm just trying to go through the notes of all the different matters and the 3 steps. I think that for the overall first step, again, this was not a general warrant. And I think the court today was pretty leaning towards they did not believe that this was a general warrant. And the question is whether the government's position on steps 2 and 3, again, was that those were reducing the number of individuals that they were looking at rather than expanding. So while they did expand in step 2, the space, they removed the geofence and they expanded the time. They did not expand the number of people. They got that for less number of people. And finally, there were only 3 de-anonymized. So that was just a minimization process, not an expansion of the search. So I wanted to give some time to Eric.
Yeah, Eric, what did the states have to add?
Yeah, well, thank you to the Program on Information Justice and Intellectual Property and the Tech Law and Security Program at the American University Washington College of Law for hosting this discussion. It's a privilege to join you today to talk about the oral argument that happened earlier today. I will also note that one of my friends on this panel recognized that there were 26 amici. There were 26 amici in support of Chatrie. There were the mighty 3 of us that were in support of the US. So there were 29 total amici, just a little lopsided there. But I had the honor of serving as the counsel of record for the amicus brief filed by Iowa, Michigan, 29 other states, and the District of Columbia, which for ease, I'll just refer to as 32 states. Not related to this discussion, but my pet theory about why the DC Attorney General is illegal didn't stop me from welcoming him joining us on this amicus brief. So that broad coalition of 32 states came together because they bear the primary responsibility for investigating and prosecuting criminal activity within our borders. And at least to date, we've had the second best result that any amicus could hope for in any given case. The second best, of course, being the justices raising your amicus at argument. Justice Kavanaugh specifically talked about our amicus brief and noted that it was an unusually broad bipartisan group of states to come together onto an issue. And I think the reason for that is simple. It's because this is a really important problem. Solving crimes is something that is vital. There is no greater tax or burden on some of the people in the United States that are facing some of the hardest circumstances than crime, and an inability to resolve crimes is tragic and leads to horrible results, which is why you could get such a broad coalition together. And of course, you know, the crux of the argument is whether these geofence warrants are more like the historic and derided general warrants, or whether they are just a judicially supervised tool that allows law enforcement to obtain location history information to generate critical leads and solve crimes. The states happen to think it's more like the latter rather than the former. And during the argument today,
Yeah, can I just say, let's go ahead and shift the conversation into the argument. And Eric, since you're on the topic, it sounds like you got name checked. That's obviously something that's you know, a welcome sign if you worked hard on a brief as you guys did. So overall, where did you see the justices sort of through what prism on the privacy versus property theory of the Fourth Amendment and the reasonableness of this three-step process? What were your observations among the justices?
sure. The the justices, I thought, seemed split along several different vectors. It wasn't clear to me where exactly a majority was going to end up. I think it could go anywhere from a 6-3 in favor of the government, likely though there with a Justice Kagan and Justice Gorsuch swap, with Justice Kagan maybe siding with some of the more traditionally known as conservative justices. I could see it being a 7-2 against, with Alito and Thomas disagreeing with reversing. I could see something even weirder, like a 3-2-4 type situation where maybe the chief and Justices Kavanaugh and Barrett agree that the underlying decision should be affirmed for one reason or another, that Justice Thomas and Alito believe that the case should be affirmed because they shouldn't have taken the case at all, and the other justices dissenting. And before I pass the baton, I do want to note that there is one odd quirk of Supreme Court practice, which is that it takes 4 justices to grant cert and take the case, but 5 justices can dismiss a case as improvidently granted. So there is always the potential that there were 4 justices that really wanted to take the case and the other 5 didn't. And after all of this time and effort and the 29 amici and the argument, that the court could just decide to dismiss the case entirely without anything else. And frankly, that would have a certain amount of poetic justice given how messy the underlying circuit court opinion was, which was a en banc full court opinion from the Fourth Circuit that, if I recall correctly, I think was a 7-7-1 split with no actual binding majority opinion. So it would be pretty funny and apt if the end result was to be some kind of mess of a majority. But I think more likely than not, if I were to make a guess, I would guess that I think there's going to be an affirmance, even if there's not necessarily an agreement as to the reason why.
So Laurel, maybe let me circle back to you because we just heard that you're going to lose. Is that the way you view it based on the argument?
That is not how I view it. I think that, I mean, I think you have to go back to the two major questions, which is, was there a search, and then was this warrant constitutional? And I think we do have probably at least 5 votes on was there a search. And I think that's actually pretty significant, given that, as Mr. Wesson just said, below there, the Fourth Circuit was evenly split on whether there was a search at all, with 7 judges saying this data is not protectable at all. And I think I'm not sure that there is a unified theory as to why there was a search. I think there might be some division between them. Justice Gorsuch, for example, really likes the property theory. I'm not sure some of the other justices do. But I do think we have at least 5 votes for this was a search, therefore you need a warrant. And then I think we might get there, and I think we will get there, on a narrow position as to why this warrant was not sufficiently particularized. And I think even somebody who was, say, like somewhat skeptical of the step 1 argument, like, for example, Justice Jackson, seemed very troubled by the fact that this warrant authorized 3 steps at which, like, successively more data was turned over, albeit on smaller numbers of people, and the government got to choose who those people were without going back to the magistrate judge, effectively putting Google in the position of a magistrate. And Google is not a magistrate. And so I think that what I could see happening is a majority opinion on there was a search, and then a narrow opinion on this geofence warrant being unconstitutional, and a remand to the Fourth Circuit to decide the good faith question, which I think is, given that the court did not grant cert on that question, I think that's the right move.
If I can jump
Yeah.
in, I think everything Ms. Raymond said is plausible, but I think it's going to be even less satisfying than that. I think they're going to assume without deciding that there was a search, and then they're going to get to the merits. And that's where I think and I'm not sure exactly what the reasoning is, but that's where I think you're going to get a very narrow ruling affirming the judgment below. And the reason I think that is I think the search question is really interesting and really hard. And I think that the judicial minimalist type in the likely majority, if the case is going to go the way that I anticipate it is, aren't going to want to answer it. And they don't have to, because they can just assume it without deciding. As for the good faith exception, that's actually kind of the reason why I think they're not going to get there. I think that, and I know Mr. Unikowski had the opportunity, or kind of got into a little bit of a back and forth about that. He was put in a bad place. It was the Supreme Court's fault. They should have taken the question if they wanted to reach it. But I don't think there's any plausible way that the Supreme Court or the Fourth Circuit is going to ultimately find that there was not good faith in the application. And I think that this is one of those, whether it's bad facts make bad law, hard facts make hard law, their understanding of that underlying reality is going to color what I think the actual end resolution is going to be, even if they don't refer to it. But I think someone will.
Yeah.
I think it's also interesting to point out that towards the end, the justices were trying to get some thoughts from both parties as to, well, what if we just say, in steps 2 and 3, what if we just issue some guidance? Let the magistrates decide, which that kind of, led me to think that maybe they're thinking, okay, we're not going to say these are blanket unconstitutional, but because they seem to be at least some buy-in and some reluctance to say the blanket unconstitutional, because there has been arguments made as to how helpful this can be. In like in this case, they did find a bank robber. There have been other cases. I mean, I know there have been other cases to the contrary where they have, and those were, in several of the amicus, they were pointed out cases that they, investigated innocent people have been proven to be not the actual criminal. But my point being that the justices seemed inclined, at least, again, I mean, who knows, but they appear to be inclined to saying, well, you know what, maybe what we need to do is just put out some guidance out there, some goalposts, and then let the magistrates work, the actual search protocols, in more detail than they were here.
Yeah.
Caitlin, what do you think?
I could see a kind of needle being threaded, Veronica, between your position and Laurel, yours, which is that the government here has to abide by the warrant standard, but that warrant standard is governed by some sort of reasonableness. What that reasonableness looks like is up in the air, whether it's just reasonableness or whether it's a particular bounding in time and space around how large or in what time parameters a geofence can be granted. I will say Alito and Kavanaugh were the staunchest voices against Ubikowski's arguments on behalf of Chatrie. Alito did question, Eric, to your point, why today's case should even be decided rather than mooted. They started today off with noting that Google no longer fulfills geofence warrants, no longer has the capacity since changing its practices from offering storage server side to on device. They no longer have sensor vaults. It's no longer responsive. I will say that argument took up very little oxygen in the room. I think a lot less than we all thought it would. So I just can't imagine this case being dismissed as improvidently granted or mooted. Two, the justices, including Barrett, seem very concerned about two particular things. One, that the government couldn't appropriately distinguish between a geofence issued over a public space, where the fence would scope in this credit union, for example, and one where a fence would scope in private homes. And so Fagan there refused to acquiesce this point that a geofence over a private residence would require a warrant or would be particularly sensitive or concerning. Seemed like a really hard pill for the court to swallow, and I could see him walking back through the arguments. And at the end, he said, "Well, we could make that argument, but might be a difficult one." So Laurel, interested in your read there. And then two, he did seem really concerned too that if the court determined that this is not a search, such that it did not require a warrant, that similar reverse and even traditional searches could be upheld for Google Photos, for Google Calendar, and for Gmail. And for those more, let's say, traditional cloud storage options, it sounded like the bench was saying, well, we use those things too. This is like a everyday kind of concern. I will say, interestingly, I think none of us expected Justice Jackson to be so particularly focused on the multi-step process and whether sufficient narrowing occurred at each step. Noting there that the narrowing that took place was not at the government's behest, but due to Google's strong adherence to user privacy interests. So she might be trying to push for more of a warrant per stage or particular narrowing per stage process, but difficult to say.
Yeah. Laura, what did you see?
Yeah, I think Laurel nailed it with her guess that a majority of the justices are going to find that a search occurred in this case. Unfortunately, I do think that the ultimate decision will be largely unsatisfying, especially when you consider the procedural history and how this case got to the Supreme Court. The question of whether a search occurred within the meaning of the Fourth Amendment, that question broke the Fourth Circuit. The three-judge panel said no, but then when it went en banc, you got a split 7-7. Seven justices said yes, seven justices said no, and one justice just declined to answer. I think something just flew behind Caitlin.
Or just hit my window. So absolutely why.
Well, hopefully that's not an omen. But I think getting back to what really is the important question in this case is, when does a search occur? In Carpenter, that question heavily divided the court. You had the justices agreeing that, yes, there's a reasonable expectation of privacy in CSLI, but ultimately a lot of justices disagreed on how you get to that conclusion or if that's even the correct conclusion at all. And I think that's going to ultimately be what happens here. I don't necessarily know if I believe that Gorsuch is going to abandon his property approach in this case. Now, I did find it extremely interesting that he didn't really mention it at all. In fact, that issue was heavily briefed by, not only petitioners, but a lot of amici. And the justices kind of just ignored any attempt to sort of get into that by petitioner's counsel today during argument. And I thought it was extremely interesting that Gorsuch himself didn't really bring it up. He asked one question about sort of what positive law says about digital records and whether and user ownership, but that was pretty much it. So all in all, I think that even if it is a positive outcome for Chatrie in the sense that the court decides that, yes, this is a search, I don't think it's going to solve the bigger issue that's currently plaguing Fourth Amendment jurisprudence, in that lower courts need guidance in answering that question.
Yeah, I wonder, I'd be curious. I mean, this does not, given how common this practice is, this is the facts of this case do not seem to be the best vehicle, in part, the fact that Google's the party collecting the data instead of the cell provider, the fact that that service is no longer available. But what do you let's assume for a minute that the question of search is either assumed or decided in Chatrie's favor. What do we think the guidance? I'm hearing different things of let's throw it back and make them do more work to sort of give us guidance, but any goalposts, any kind of guidance about what the lower courts are supposed to do if we assume that this is a search and that warrants are required, and then what the contents of those warrants should look like? Anyone? Open question.
Well, I guess what I'll say is obviously the Supreme Court takes so many Fourth Amendment cases that they'll just resolve it at the next one, which I'm sure could be within, 10, 20 years easy. I don't know the last time they took a Fourth Amendment case. I guess technically case against Montana was a Fourth Amendment case, but they tend to be a little shy about the Fourth Amendment. And as for guidance, I think I really think that they are going to issue a fairly unsatisfying opinion that does something like assumes there is a search, assumes that a warrant is necessary, affirms on some kind of pretty narrow basis it's hard to apply, and then say go forth and prosper, and all the district and appellate courts are going to struggle to apply it until they take whatever the next case is. That is my guess as to what's going to happen. But
Yeah,
that's worth what you pay for.
I I think they might say something also like, I mean, something like I said before, they were trying to get at, yeah, you can issue these warrants, but you're going to have to be very specific. Either just do just a step one warrant, and then have to get warrants if you want anything else. Or if you want to do a multi-step, you have to have some sort of way to go back to a magistrate or something like that, or be more specific. But again, while they were asking the question, they were very reluctant to say what they were very specific. I think it was Kavanaugh, I think, correct me if I'm wrong, but he was saying, well, or Gorsuch, one of them was saying, oh, well, we're just going to have to, let them, they need to have the ability to do their own interpretation. They know their districts better. They know their areas better. So they seemed reluctant, at least the judge that was speaking seemed reluctant to put too many strict requirements on this. So yeah,
Can I ask one observation? I I may be wrong, but my perception is that the chief has a particular interest in stepping in to write when it's a case trying to frame the way we think about technology in these new settings. I mean, certainly Carpenter, to me, after that argument, I had no question he was going to write, because he really wanted to, make this acknowledgement. Hey, people, we see you. We recognize that your phone is essentially an appendage, and therefore that's a material, this is a difference in kind. And I guess this is another difference in degree, difference in kind of moment, but little messier. So I'm not sure I see the chief wanting to write this, but the chief, Kagan, where do you think, and Sotomayor, they were active at various points in the argument. What did you take from their interventions, and Barrett as well? But I'm curious about specific justices. Any observations about how they they appear to be looking at this case.
One thing I noticed about Sotomayor's line of questioning is that she seemed to sort of echo her concurrence in the case of United States versus Jones, where she sort of put forth this mosaic theory where it's the quality of the information rather than the quantity of the information that matters. And I thought that was interesting. And I was kind of hoping she would carry that over into this case. And it's nice to see that she sort of asked questions along those lines. Um, I mean, from my perspective, I was kind of hoping that Barrett might be able to entertain or might be willing to entertain the property theory that Gorsuch put forth in Carpenter, but that kind of fell flat today. And so I was interested to see where she was going to fall along ideological lines. But yeah, it looks like, in my opinion, I think she's going to fall into the camp of reasonable expectation of privacy. I think this is ultimately going to be a decision like what we had in Carpenter, where the chief, Sotomayor, Jackson, Kagan, and ultimately Barrett say that there is a reasonable expectation of privacy for this very narrow reason, and we kind of just get left with that.
I'll be pretty surprised if any of the self-styled originalists on the court extend Katz any further. But again, I've been surprised before.
Yeah. Laurel, you were going to say something.
Yeah, I think that one interesting thing about the reasonable expectation of privacy and the way that geofence warrants are structured is the justices did seem very concerned about intruding into a home. Like this warrant, like the first step is just public spaces. Although if you look at the confidence intervals, it could have swept in people in private spaces. And then, but at the second step, which is like how these warrants are designed, it's kind of inevitable that some people will be followed into their private homes. And also, you don't know that beforehand. If you're just following where people go, they could go into a private space. And it's not, you can't decide that a warrant is constitutional or not after by seeing what turns up. It's, you have to decide in the first place. So I think that inevitably there is a risk of intruding into private spaces and places where you do have a reasonable expectation of privacy, just with how these work. So I think that to the extent that they embrace that theory, it could lead to some very interesting results.
Caitlin, go ahead.
I agree, Laura, with you about Sotomayor following the line of thinking on Jones and how movements show patterns of life. I did think it was very interesting that she noted how sensitive a single location or single moment could be, which kind of builds on her mosaic theory in Jones. And Eric, I do agree with you that the court doesn't take up Fourth Amendment cases enough, so that's why we need to get it right here. And I think we disagree on what right looks like. Mike, to your point about why this was the right vehicle or the right case, it is a tough one. It is hard set of facts. It's 19 accounts, 3 unmasked accounts. But I would welcome everyone to review Google's brief about particularly broad geofences that they've seen that have been or had their gags or seals lifted. And so one was over 2.5 square miles in San Francisco for a period of 2.5 days. Another one was about 490 acres in Albuquerque, New Mexico, which would have covered thousands of users, including those attending a funeral service. And so this is just one example of a geofence, and it is definitely not the most egregious.
Yeah, I think we're about going to hit time, and I would say I want to thank you all for these observations. I do. The only other thing, a little bit to the point Caitlin was just closing with, is they're always worried about the collateral consequences of a decision, and particularly here where we have a widespread common practice that is both effective and potentially quite intrusive. And as the justices try and wrestle with those two kind of pulls, I'm going to agree with you that they're going to end up with something unsatisfactory because they're not going to be willing to draw any hard and fast lines and say you can't use this tool at all. I just don't see that. But I also don't see we're going to give law enforcement this amount of discretion in the drilling down process. That seems to me like that's going to be a bridge too far for at least 5 of them. So I'm with you. We'll have to see. Yeah, we'll have to see, how this turns out. But I really want to thank you all. I'm sorry to the audience that you didn't get to time for Q&A, but this was a complicated case to work our way through. And sometimes I come at the end of these and I think we're pretty sure at least about what the result's going to be, if not the reasoning. And I would agree that Eric presented us at the opening with this. You could imagine this going either way with different coalitions lining up around different positions. And I think the minimalism impulse is likely to assert itself because they're a little unsure about what the guidance should look like and probably want some more percolation. That's my own observation is uh, maybe it's not time to dig this one, but maybe we need a better second bite. And so we'll give you something and we'll come back and tell you more the next time. All right, with that, I want to thank you all, and you're hearing the loud applause of the audience that you can't see, but I know they very much appreciate the time and effort you put into being with us today. And this session has been recorded. Once it's been transcribed, we will have it on our Pidgip video channel on YouTube, and please feel free to refer your friends and colleagues to it. And we'll see, they're going to have to tell us by June 30th, I think, what this is, and we'll all wait with bated breath. So thank you all so much. Have a great evening, and we will see you the next time the court does this.